What's up with Justice Thomas saying that legal precedents are not the gospel? I know nothing about law. Are legal precedents supposed to be gospel, or are they not supposed to be gospel? What's the point of concern about Justice Thomas saying this? Answer: legal precedent is the legal philosophy that similar cases should have similar results. Rulings by higher courts create precedent that must be followed by lower courts. When precedent is not followed, it is usually grounds for an appeal and reversal of the decision. The Supreme Court, however, is in a different position. It is the highest court, which means their decisions are final. The only precedent the Supreme Court typically follows is their own, but as the Supreme Court, they can change precedent. The court typically refrains from major shifts in precedent, but it does happen. Plessy versus Ferguson set the precedent that you could racially segregate if the facilities were separate but equal. The court changed precedent by overruling Plessy in Brown versus Board of Education. Similarly, Baker versus Nelson ruled that there is no constitutional right to same-sex marriage, and prohibitions were completely constitutional. The Supreme Court changed their mind and disregarded precedent in Obergefell versus Hodges, which said same-sex marriage actually is a constitutional right and can't be restricted. And recently, Roe versus Wade said that abortion was a constitutional right and abortion on demand for any/no reason must be made legal before 24 weeks of pregnancy. This precedent was modified in Planned Parenthood versus Casey to say that the government couldn't impose an undue burden on the right to an abortion before viability. And finally, the court overruled Roe and Casey completely in Dobbs versus Jackson Women's Health, allowing abortion to be regulated at any point in pregnancy by the states absent a threat to the life of the mother. So TL/DR. Precedent is not gospel for the Supreme Court. They can and do change their mind. However, when they do change their mind, it is often a significant and impactful event. Additionally, while precedent is not binding on the Supreme Court, it might as well be gospel for the lower courts, as disregarding precedent is grounds for overruling a decision.